this morning's docket. That is case number 114543 in the matter of John Thurston.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I'd ask for 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. As you're all aware that this is an original proceeding in attorney discipline, there was a formal complaint filed in February 2nd of 2015. There eventually was a joint stipulation of facts that were filed by the parties, including respondents' admission that he immediately withdrew $10,000 of client funds. There was no stipulation to the actual rule violations, and so we went to a hearing. At the hearing, the respondent testified that his current practice at the time of the hearing was to track all of his time, and that's found at the record pages 32 and 46. He testified that the scope of this particular representation was through arraignment, which is transcript at page 25, and that the scope was plain in the engagement contract. Whereas the actual contract read that there would be additional fees if the case proceeded to a jury trial. It did not specify termination at arraignment, and that's at the transcript in page 61. The contract also provided that upon client termination, the fees would be calculated at $250 an hour. He did not track his time, which is what it created the problem in this case. At the hearing, he estimated that he worked between 70 and 80 hours on the case, and so the panel imputed for a total of $17,500 and determined that he needed to refund approximately $5,650 to the client. He has refunded that money. But when pressed, he then testified that he was still not depositing fees into the trust account. So the hearing panel recommended that within 90 days he submit to an audit by our auditor, and within 30 days provide written policies and fee agreements to us for review and approval. On September 29th, our auditor requested the standard compliance audit information. In November, the respondent provided bank statements from December 2013 through January 2014. There were no client ledgers, and the trust account for the most part was zero. On February 26th, we received an email with an attachment of fee and trust policies, procedures that lays out 9 points. There was no fee agreements or any client letters included with that information. Our auditor finally completed what he could, which was not a complete audit. It wasn't a triple reconciliation because we did not have a master ledger, a client ledger, or a checkbook register. But he did conclude that the respondent was on the right track, but they would benefit if they would have a master trust account ledger, that they would maintain that ledger, and they would have individual client ledgers and a checkbook register. The panel ultimately concluded that the respondent's conduct violated KRPC 1.15a because he didn't deposit the flat fee into the trust account, which is required. And the panel noted that it needs to remain in the trust account until the representation outlined in the engagement contract is completed or if the client has agreed to partial withdrawals. The second rule violation the panel found was KRPC.
I'm sorry, can I just interrupt you because I'm a little confused. Were all of the facts that you just recited that flowed from the audit before the hearing panel?
We didn't have an audit before the hearing.
Okay, so you just recited a lot of facts to this court that the hearing panel never heard.
The hearing panel required or recommended that he submit to an audit within 90 days. And so starting on
I'm just concerned with the fact that we've got a lot of facts before us now. It looks like that were developed after the recommendations made by the hearing panel.
Well, that's correct, but I don't know how to communicate to this court whether or not the respondent followed the recommendations.
Sure, I guess I'm just questioning that whole procedure. Maybe this isn't the. Can you just comment on that? I mean, what are we to do with that from your office's perspective? What would you like us to do with that? To consider those facts as we weigh this?
That is where I'm heading. The recommendation actually is going to change because at the hearing we talked about the public censure with conditions, and it is our office's position that because he did not follow the recommendation and complete the tasks that were recommended, that conditions aren't appropriate because he has shown that he won't follow suggestions. And so the recommendation today is that he be sanctioned by a 90-day sanction or a 90-day suspension, which we're using the docking case, which is at 282 Can 715, as our example for that.
Let me just ask kind of a global question on this whole procedure. How is this fair to the respondent? For the development of new facts to happen after the fact finder has rendered its findings, and then for the prosecutor to say, based on the development of these new facts that we're in possession of, but we've never actually presented to a fact finder, we want to impose a more severe sanction.
Okay, well, this case was about handling of client monies. And to be honest, there is confusion amongst the bar as to how to deal with flat fees. And so one of the things that we would ask is that this court look at paragraphs 21 and 22 of the final hearing report and indicate on that. Additionally, the Barker case stands for the proposition that activity between the final hearing report and being in front of this court can be considered by this court. And that was the case that I was using, that the panel on its own determined that there should be this audit and these other things. And I believe that in order to be able to analyze what is the appropriate sanction, I think you have to look at, did the respondent follow what the recommendations were? If so, great, we would have the same thing. If not, under Barker, you are subject to additional potential sanctions. And in fact, in closing, I actually did suggest that if he did not follow what the final hearing report was going to be, that he could be used as an aggravating factor under the Barker case.
By us. Counsel, I know in some cases we have communications from the respondent between the time of the panel hearing and the very common scenario is when there's been a recommendation for some sort of therapy or evaluation, and those take place before the case gets here. And then it's in the respondent's interest, of course, to submit something to us to let us know that in fact he or she has followed through with whatever the recommendations are. So we've had those kinds of cases. We don't have that here, though.
No.
We don't have a position from the respondent other than whatever's going to be said orally to us today.
Well, there was no, I mean, I kind of envision this because this whole censure with conditions is kind of something that has been resurrected, and historically, the first two cases came out in 2008 before the court had amended the rule allowing for probation. And so I think at that time the court was trying to have a probationary kind of scheme when it didn't have a rule. Now we have probation that has certain requirements, and part of the requirements is for the respondent to file an affidavit with this court
Right.
indicating compliance.
Right.
And in this case, I wouldn't obviously have objected if something like that had been, and I would have appreciated, because standing before you, I cannot say that everything has been corrected. I can absolutely tell you I have never received a fee or an engagement contract for review. I don't know if he's using his trust account. I don't know if he's tracking his time.
And therein lies the rub. And that's what my colleague is pointing out, that you're not sure because you're not a fact finder. We haven't heard from the respondent. These facts continue to develop on the ground, so to speak, while this proceeding goes forward. And frankly, there's a question in my mind, kind of a more basic question, as to whether, what force do the panel's recommendations have pending hearing before us? Because this is the body that decides discipline. The panel merely recommends, as you're well aware. So I think this is a very interesting area, and this may be kind of a test case. The other thing is that this kind of hybrid public censure with recommendations is just complicated. I appreciate that there are a couple of historical cases, but it's been a rare a rare bird. And I think it lends itself to confusion on both of those grounds, on kind of a procedural ground and on ultimate substance of what the facts are when
Well,
we're deciding.
I'm sorry.
No, that's okay.
We would obviously appreciate direction from the court on how to handle these things. And this isn't going to be the only case this week that involves a censure with recommendations. So I think the panels are trying to find situations that, in this case, it most likely would have started out as a diversion, but he already had prior discipline, which excluded him from that program. And at
Would
the
you
time,
say also it's the panel's effort to give someone probation who hasn't sought it?
I
Because
hate to
the probation rule is very clear. If you want probation, you need to show up at the hearing having put a plan in place. And it has to be sufficiently detailed, and if that hasn't happened, then probation just generally, as a procedural matter, isn't available.
well, I would generally agree with that statement, but this court has on its own given people probation that had never filed a probation plan. So I think there's definite confusion.
But that again would have been a very rare situation.
Correct.
Generally speaking, we've also said many times you didn't ask for it, so you're not getting it.
And that is where my personal comfort zone is. We have rules that need to be followed and consistently applied across the board.
I
Right,
want
thank
to ask, the hearing panel said, we want three things to occur shortly after our report. Number one was the respondent was supposed to permit an audit of his trust account, and you're saying that occurred.
I'm saying not a complete audit because he did not maintain a client ledger. So basically what our accountant was able to do was to sort of trace monies that had gone into the operating account and kind of align based upon the names on the checks and when work was purported to be completed.
Whatever was there, he permitted you to go look at, regardless of whether he had a good trust account administration or not. You were allowed to do it, which is
Correct.
all that they asked, was that you be permitted. So you looked at it, you found some problems, but
Correct.
he did what he was supposed to do. Then I want to skip over the second thing for a second. The third thing was, did he pay the $5,600? Did he do that?
Yes, he did.
Okay, so now we're down to the second thing, which he's supposed to submit written policies regarding time records and fee agreements. Did he do that?
He submitted policies last week. He did not submit fee agreements. And if I may go back to the audit, we understood that he did not have a functional trust account at the beginning. And I believe that's why the panel gave him some time to get the client ledgers going, to get everything going so that the auditor would be able to have something to look at to make sure and to confirm that he understood and was appropriately accounting for client funds. And that was not necessarily 100% confirmed by the auditor, as the auditor said, indicated that he's on the right track, but because we didn't have all of the ledgers to be able to make sure that we really are tracking the money, that was the auditor's conclusion.
I'm just saying the hearing panel report doesn't say he's supposed to permit access to the trust account and then implement whatever you found to be deficient. That second part's not there.
Well, except for back, if you look at paragraphs 21 and 22 of the final hearing report, it talks about that the fee must be deposited in the lawyer's trust account and can't be withdrawn until it's earned. Since it's not earned until completion of task, the entire fee must remain in the lawyer's trust account until the task is completed or they otherwise agree. And then paragraph 23, failed to deposit the flat fee. And I think if you look at that information based upon the combination of an audit, the spirit of what they were trying to do is to get him to use his trust account, to use appropriate accounting practices, and then to have our office be able to confirm it so that we could come stand before you and say everything's good, let's have a public censure.
But it doesn't say that. And the paragraphs you're talking about are just what are the rules for having a good trust account.
I agree.
And you know, again, if the hearing panel wanted him to have an operating trust account that conformed with all the rules appropriately, then it should have said that in the hearing panel as to what he was supposed to do between here and there, or between there and here. So I'm just echoing the notion that it's difficult, I think, for the disciplinary administrator to come up here and say we've got a new tag and we want a more severe sanction for something that hasn't gone through the disciplinary process, because this apparently hasn't, what you're talking about. So that's why you're getting pushback.
Oh,
Okay.
I expected it, and we appreciate having this conversation. I guess our office's position is that we have a duty to protect folks, and especially when it comes to money. If there is anomalies going on, that we need to be more proactive than less proactive. And ideally, it would have been nice for us to have a joint, something that we could present to the court saying, censure is appropriate because of all of these conditions, but the parties agree have been completed.
You mentioned that there was restitution made. Is that $5,650?
Yes.
Okay, so that.
And he
has
paid
happened.
that immediately.
Okay, thank you. I just wanted to get that cleared up at least.
So your recommendation today is what?
Is a 90-day suspension with a reinstatement requirement that he show us that he has client ledgers, that he's depositing money into his trust account, that we review the fee agreement, and that he's following his operating procedures. And again, the docking case is the basis for the precedent for the 90-day, 60-day sanction. I apologize.
Are you seeking 90 or 60 here?
60, I'm sorry.
All right, thank you. And docking is your case.
Right. And we would ask that he be required to produce all of the information that normally is produced during a compliance audit, and his engagement contracts, basically our interpretation of what the panel recommended. Justice Johnson, I'm sorry.
I did have a question about page 11 of the report. It was the middle of the 3 conditions that the panel recommended. It says, second, the hearing panel directs the respondent to submit written policies regarding time records and fee agreements which are in compliance with the Kansas Rules of Professional Conduct to the Disciplinary Administrator's Office for approval within 30 days of the date of this report. Did he submit written policies?
He did, and I received them via email. 1 second. On February 19th, and it's a list with bullet points. And if the court is interested, I can, or he can explain what it is. But it appears to be appropriate use of office policies when it comes to accounting.
And the condition was that these are in compliance with the Kansas Rules of Professional Conduct. Have you or anybody in your office reviewed that sufficiently so you can declare, yes, they are in compliance?
I can.
All right. Very good. Thank you. Any further questions? Thank you, counsel.
John Ambrosio on behalf of the respondent, may it please the court. Let me start at the end. He is complying with the requirements of the panel, but for he did not submit contracts that he always uses to the disciplinary administrator's office. It's important to understand that any fees.
He also didn't submit some of the according to Ms. Knowles, he also didn't submit some of the information required in an audit. And an audit is one of those requirements from the panel,
did.
is it not? What
That's
about
correct.
the check register and several other items that you're...
I think it's important that you understand they ordered an audit. The panel suggested an audit. We came up, my colleague and I came up with the best way to do this. Instead of having an investigator or a accountant sitting in his office, we'll submit you everything. If it's not good enough, you let us know and we'll supply it. So we originally supplied stuff, and we found that they weren't sufficient for the auditors, and the auditors believed. So then we started creating everything to show them that all money was flowing into the account that we sent 2 weeks ago or a week and a half ago, office procedures, how the trust account is to be operated. So we're not in compliance as far as the panel report, as far as sending to the disciplinary administrator's office contracts. But everything else, I believe, is being carried out. And the important thing here is that originally this gentleman was not putting flat fees into his trust account because he relied on all the documents, including the money of others, which is the Kansas Bar Foundation, that suggests that if it's an advance fee or a flat fee, and it's still up on their website on page 5, that if it's a flat fee, it doesn't go in the trust account, it goes in your operating account. But he accepted what the panel said, and every nickel, even a $500 on a first DUI, is going into the trust account. And then things are transferred as earned at his hourly rate. So the important thing is that he's comporting himself correctly. The problem is, and I think it's time that we get something from this court that tells us, what is a lawyer to do on a flat fee? What is a lawyer to do on an advance fee? Criminal lawyers, forever, would take a $20,000 fee, if it was a flat fee, through all the representation, and it didn't go in the trust account. It would go in their operating account. Now, they were required to keep track of their hours, or they were required to show that that fee was earned upon a client firing them and withdrawal. So we need something in this court that says all money received by a lawyer, advance fee, flat fee, regular retainer, or any other type of retainer, should go in the trust account. And then you draw down against it, because I think the case law is pretty accurate. If I say to you, I'm going to handle your DUI for $2,500, and I don't have my hourly rate in there, I can't take a penny out of the trust account until your DUI is over. But if I put in there, I'm going to do it at $350 an hour or $300 an hour, as I use those hours, then I can draw it down. And that's what we need in our contracts, and we need a bright line rule from this court. When we started, John and his partner, Mr. Thurston and his partner, were not putting money in their trust account. The money is going in their trust account now. They have contracts with their clients. They are developing client ledgers, trust account ledgers, so that they can provide these to the disciplinary administrator's office. They have done it slowly. They have not done it with
Mr.
alacrity.
Ambrosio, okay, I'm sorry, I'll just cut you off there because you appreciate that. You sort of lead into my concern here, which is I understand your sort of substantive request for direction from the court, and that makes sense. I'm more concerned with kind of the procedures as to how we got here right now. So if you'd indulge me in a few questions, just kind of, you do this work a lot. You appear in front of us on lots of these disciplinary cases. And at least in recent months, we've had a number of instances where what I would characterize as due process concerns have been raised, and they've come out of attempts, and I think attempts very much in good faith on all the parties, to say we can ad hoc, we can just kind of get together and ad hoc present a settlement, and then, like as often happens, and as I believe has happened here, it doesn't pan out, and now we've got parties that have disputes, and they might be factual disputes as I interpret the arguments we've heard here today, and they're standing in front of us, and what really ultimately ends up being harmed is the respondent's due process rights. That's my concern. So the question I've talked a lot. What is the nature of this process? Is it an adversarial process?
Sure it is.
And so what should this court be looking at in terms of how are we to evaluate these kinds of cases where we sort of, my colleague and I got together and everything was going well until, and now we're here with the until.
But don't the cases say, maybe I'm wrong, maybe I misread Conwell, maybe I misread Document, all those cases, maybe I misread Ponta Flores's cases where I represented him, where you said, this is what you're going to do. And if you don't do it, then there should be a motion or an order to show cause, and we drag you back before this court to say you didn't do these things, ergo, you're suspended.
Those are typically cases where there's a discipline imposed, and then as a matter of grace, essentially it's suspended. A
True.
suspended suspension.
And Well, I'm not sure about the
But,
common law,
but your
yes.
client's now in a position where the disciplinary administrator is asking for a greater sanction than was requested and was recommended by the hearing panel.
Which they
That's
can.
my,
I think they can do that. I think our rules are, it's just advisory.
well, what's
They-
your position on that recommendation?
I think it should be a published censure, period.
And-
And he should comply with the dictates of that panel. He should
And
follow
understandably,
religiously.
and you think that because you have a factual disagreement with the recitation made by the disciplinary
That's
administrator.
fair.
Okay.
That's fair. That's
You
fair.
just see
I
the
hate to
difficult
admit it, but
position
that's
that the
fair.
court's in.
That's fair.
Okay.
That's fair. And I think what needs to be done is a bright line rule, what we do on these every bit fees, and we need something from this court because nobody knows what to do. And when this case comes out, there are going to be 100 criminal lawyers over the state that are going to be either self-reporting to the disciplinary administrator's office or they're going to be jumping off buildings because people take flat fees all the time and they don't put in their trust account. This case, once it goes out there, will warn every one of these lawyers, every farthing must go in that trust account. Every nickel must go in there. He is following those dictates now. He is doing everything that's necessary. And where Mr. Thurston made a mistake, and I agree with my colleague, he didn't keep track of hours. But I think the one thing we've forgotten here is the contract was only through the preliminary hearing, and he had gone through the preliminary hearing. Now, I think the better practice is when a client says, tell me how you spent the money, even on a flat fee, you should explain that to him. And Mr. Thurston was not keeping track of his hours, which is another thing that they are now doing. Both he and his partner, and his partners here today, are now keeping track of every second that they spend. I see we're running out of time, and I think it's very important that my client discuss this matter with you.
Do we have any further questions? Very well.
May it please the court, I didn't trust myself to try and remember everything that I wanted to tell the court this morning, so I made some notes. As a defender of the accused, and that's all I do. I don't draft wills. I don't handle divorces. All I do is defend the accused. One of my regular duties is to find the silver lining. It's to determine what good, if any, can be found in an otherwise bad situation. To say that I put myself in a bad situation here is clearly a drastic understatement. But there is a silver lining. First and foremost, I am now doing everything right in terms of my trust account and billing practices. As soon as we received the panel report, at that point, every single penny on any case went directly into the trust account. There are no exceptions to that. Each and every client has a trust ledger. We have created a trust ledger. Those have all been submitted to the disciplinary administrator's office. We do that so we can track each and every dollar. There are no fees that are transferred out of our trust account into our working account until they are earned. All time spent on cases is tracked as well in tenths of hours. The mistakes that brought me before you today have been corrected, and they will not be repeated. There's actually another silver lining that I've found here, one that's a little less obvious, a little less concrete. This experience has made me a better lawyer. I meet with and help many people who have made mistakes and are in fear of what those mistakes will cost them. Now I can truly empathize with many of them. Standing before you today, I can tell you without equivocation that I am sorry. I'm embarrassed, and frankly, I'm terrified. I tell my clients, try not to worry because worrying is not going to change anything. I've worried every single day since I got that gray envelope in the mail. I love being a lawyer. Every day, I do my very best for my clients. I'm proud of the work that I do. My children are proud that I'm a lawyer. My 13-year-old daughter wants to be a lawyer. She saw me this morning, saw me putting my tie on. So you got a court today, Dad? I said, yes, I do. What kind of case is it? I didn't tell her. I don't want her to worry. but I couldn't tell her. I promise you that I am doing and I will continue to do everything in my power never to appear before you again. Thank you.
Thank you, Jim. It's also important to notice he did pay that $5,000, but I think it's important to show what type of person I have here. He and his partner placed the entire $26,000 fee as soon as this complaint hit, or soon after, or when the complaint was filed, in an account. So in case he had to give the whole amount back, he would give the whole amount. They took it out of their profit and put it in there. I think that goes a long way to showing the difference between somebody who just takes the money and runs or really works for the client. So they were willing to do whatever was necessary. If the panel had said you give the 23 or 26,000, they would have done that. I think that's important.
Would you address why you disagree with the recommendation today of a 60-day suspension?
With all due respect, my friend, because they're wrong to ask for that. The published censure is sufficient. To give somebody a sanction of 60 days takes him out of the criminal practice. It's all over. Don't kid yourself. That 60-day sanction, he can't just come back 60 days later and start practicing law. He'll be behind the 8 ball 7-8 months. That's number one. Number two, and maybe more importantly, he made a mistake and he's cleared it up. And this court and all courts should be about forgiving mistakes. And he's made repentance. He's been up here. He's had to be here. That's why I disagree. We've talked about this a lot. And we all have a good relationship. And we do try to work ways out to save the lawyer and to protect society. I think that's our job. It's adversary, but it's adversary in a friendly way. He has learned. That's why I'm against it. And to slap him with 60 days or more is dead wrong and ruins his practice and kills him as a criminal lawyer. People never forget when you've been suspended. And the good criminal cases, if there can be good criminal cases, won't come to this office again in Manhattan because of that. That's my view, Your Honor.
Very well.
I didn't mean to be.
Are
No,
the factual representations that the disciplinary administrator made regarding what happened, what's missing out of all this audit process, are
They're
those
accurate.
facts accurate?
They're accurate. Some of the things, go ahead. Some of the things have been turned over. The contracts have not been turned over. And there's not a master. There are individual client lists, but not a master.
There's not a master client ledger. We've turned over the individual ledgers that we maintain on every single client that has money in our trust account. We've turned over bank statements. We've turned over photocopies of deposit slips. We've turned over everything that we have.
We were not suggesting that they were being anything less than honest on that. We've done the best we could to turn it over. We're still shy a couple of things. That's the only way to describe it.
Any further questions?
Is there a reason for that delay?
As far as the fee agreement, that's, frankly, I thought that we had submitted that. There have been a lot of emails and a lot of scanned documents that were sent. I know that at one point, when I got an email back from the auditor, he said, well, I only have a certain number of the client trust ledgers. And I thought that's strange because we sent dozens and dozens. And so I resent them, and then we later got an email saying, okay, I did receive them originally. So I'm not standing before this court promising that I sent that, because in the confusion I may not have, but we're more than willing to do that. We do written fee agreements in every single case. So
Further questions?
Yeah, there was one aspect of this case that bothered me besides the accounting, and that was that apparently the court was concerned about the performance at the preliminary hearing and granted that defendant or substitute counsel leave to redo the preliminary.
That's correct.
That's a very unusual circumstance, and so that, to me, that's a little problematic, not just how you handled the fee, but how you handled the client.
Although I think we have a difference of opinion how it was handled, and I do know that after the second preliminary hearing, more charges were filed, and the accused, now the defendant, is in prison. Not because of anything that he did. But I hear you, but that wasn't raised at the hearing. There's no question of competence raised at the hearing.
Right. Any more questions? Thank you both.
thank you.
can you just answer, why was the audit done in this fashion where you're emailing things back and forth as opposed to sending someone 55 miles to go do the audit in the office? It just seems to me that, and maybe hindsight's 2020 when we look back on that, but why was it done this way? Or is that a typical way that audits are done?
No, it is not. And again, this is things that developed after the hearing report. As soon as the 30 and the 90 days passed, I explained to John that we were taking the position that his client was not in compliance with the recommendations and that probably would result in us asking for a higher sanction. So that was November. And we received on or about February 18th, finally the client files and a final bank statement. We did not get a checkbook registered. I'm sorry, we didn't get the trust, master trust register because as you just heard, that doesn't exist. And then on February 19th, which is what I was relying on, our accountant emailed, which Mr. Ambrosia was copied with, please note that this is not really a triple reconciliation since Mr. Thurston does not maintain a master trust account ledger, and I do not have a checkbook or disbursements register.
So all this is happening 2 weeks or 10,
right.
11 days ago?
And Mr. Ambrosia and I had discussed Larry and I traveling to Manhattan to sit down with him, but until we had something for him to sit down and discuss, I didn't see that there was a point for us to drive to Manhattan. And frankly, my schedule got to the point that
I'm not telling you how to do your practice. I'm just wondering if it was an ordinary course where you do an audit through emails and that kind of, and through scan stuff.
I will say,
it seems.
I believe what, actually I have, the compliance letter was dated September 29th. And it says, please provide the following electronic media is preferred. And the deadline was October 16th of 2015. And then it's got 7 things. And so
this is back in October when this stuff was requested.
Right. And I honestly, I believe that because Mr. Danasteel, who is our auditor, has the ability to spreadsheet things, that he does prefer like a flash drive or something. He doesn't want the actual stacks of paper anymore. So the fact that it was emailed, I wouldn't say is necessarily unusual, but there usually is a point in which he sits down with paper with the person and kind of goes through it, at least as far as the compliance exams go.
And that didn't happen here?
No.
The hearing report is dated September 16th, 2015, and now it's 6 months later, and we're still not real clear on whether there's been compliance on these financial issues?
I cannot stand here before this court and say that our auditor was able to do what would be the equivalent to a triple reconciliation compliance exam, because as you heard, there are things that aren't in existence. And to answer Justice Stiegel's kind of line of questioning about due process and things, it just seems to our office that it's in the respondent's interest to show compliance so that when they come here, there's no question about whether or not they are compliant or not. And so that's really the difficulty that we're having in this case. I cannot say that we are confident that everything is properly functioning. I don't know when they started the client ledgers. I don't know when they started using the trust account. That information those dates and things were never actually shared, as far as I know, with our office. It might have been part of some of the information that he sent as far as the audit, but because we didn't have what I would consider a formal audit, we don't have a final report. We don't have any of those kinds of
Just
things.
to be clear, I'm sorry, go ahead.
And is there a remedy so this situation does not recur? Or have you presented us with, this is what happens to the justices of the Supreme Court, it's now up to us to try to make sure it does not recur, or do you have something in mind? My concern is we're going to have more occasions like this,
Correct.
where frankly I'm a little frustrated that there's nothing more definite to go on. So if that is your plan to say, well, these were the conditions imposed by the panel it's up to the respondent to demonstrate that he or she has complied. We can't tell today whether there has been compliance. You say there has not been total compliance. Are we going to be seeing that over and over again, or is there something that you're asking us to do so we don't find ourselves in that situation?
Well, I would like to see if the panels continue with these kind of, we want certain things to occur between the panel hearing and before argument, that there be a requirement that we follow kind of the probation rule, and that there would be an affidavit that is something that is presented that we could verify and not object to, and so then everybody's on the same page as far as what the activity was between the final hearing report and argument, so that there is clarity, because it is frustrating.
Ms.
And is
Holt?
that affidavit, does that need to be a requirement imposed by this court, or can the panel itself do that?
Well, I think the court could, through this case, create a requirement that if a panel is going to make recommendations of tasks that need to be completed prior to appearing before this court, that the panel also require there be some sort of submission to this court through your court order, kind of making it as a probation affidavit kind of thing.
And why would the panel not maintain jurisdiction and say that affidavit would come back to the panel? I'm just curious why it would have to be done with this court.
Well,
Is there something that precludes that?
well, I think Justice Beyer had a point that what authority does a panel have to have anything? What authority do I have to have anybody do anything?
Exactly. I think that the most fundamental question is, what power does the panel have to require anything to happen, period? I mean, that's really the first question in my mind. It may be a good idea, but I'm not sure that it's an authority that actually exists. And so, I mean, I think the questions are really fundamental. I mean, we obviously had very specific questions about what happened here, but I'm not positive that the panel has the power to require anything to happen between the time its hearing stops and the time of oral argument before this court.
Well, and I think that's why it's considered a recommendation, and
Right.
absolutely, this court can determine.
And that's why we're having so much trouble with the recommendation of the disciplinary administrator's office being juiced on the basis of failure to, or a perceived failure to comply with requirements that may or may not have any authority behind them.
And we had discussions about that, and based upon what we believe Barker stands for, that a demonstration, I mean, we have the rule that if you fail to comply with lawful requests in an investigation, that is another violation of another rule, and arguably that could be another vehicle that we get there, that because of the conduct between could be considered not fully cooperating, that there is not only a violation of what our perception is of the panel's recommendations, but there's a violation of the actual Supreme Court rule.
But it's different, for example, in failure to comply by not showing up here for oral argument.
Absolutely.
I mean, something that we see happen.
Absolutely.
So they're just, I just think this is a road that has lots of potential problems. And
Well,
they're
as
surfacing here.
counsel suggested, we really are looking for some guidance here.
I understand.
We're looking for guidance as far as how to deal with flat fees. We're looking for guidance in the disciplinary process. And these are all questions that we don't necessarily have the authority to answer. Did you have a question, Justin?
No, I think it's been answered. Thank you.
Any further questions? All right. Thank you, counsel.
Thank you.
Thank you all for your arguments this morning and this afternoon. Court will take this matter under advisement.